altogether, including us right now. And more have been steadily trickling in as well. All right, well, I'm going to get started right now. I hope everyone can hear me. My name is Jared Dobbs, and I, on behalf of the Federalist Society student chapter at McGeorge School of Law, want to extend a special warm welcome to all of our attendees who have been able to make it tonight. The Federalist Society for Law and Public Policy Studies is a group of conservatives and libertarians interested in the current state of the legal order. It is founded on the principles that the state exists to preserve freedom, the separation of government powers is central to our Constitution, and that is emphatically the province and duty of the judiciary to say what the law is, not what it should be. The Society seeks both to promote an awareness of these principles and to further their application through its activities. I just have a couple of brief clarifications and announcements before we get started. First off, if you are a student at McGeorge and you want to sign up for communications from the student chapter, McGeorge Federalist Society, please just put your email in the chat and one of our officers will be sure to sign you up for that. Additionally, we want to extend a warm welcome to anyone viewing who's from the Sacramento Lawyers chapter here in Sacramento, as well as any participants who are coming from Professor MacLeod's School of Law, which is Faulkner. At this time, I'd like to introduce the constitutional scholars. The question of tonight's debate is, should Roe be overturned? And arguing yes is Professor Adam MacLeod. Adam MacLeod is Professor of Law at Faulkner University Jones School of Law and a lecturer in the James Madison Program Graduate School on the Moral Foundations of Law at Princeton University. He has been a Thomas Edison Fellow at George Mason and a visiting fellow in the James Madison Program at Princeton. He is co-editor of Christie and Martin's Jurisprudence and Foundations of Law and author of Property and Practical Reason and of dozens of articles, essays, and book reviews. His most recent book is The Age of Selfies, Reasoning About Rights When the Stakes Are Personal. He writes and speaks about the foundations of private law and private ordering. He serves as a legal staff officer in the U.S. Coast Guard Auxiliary and previously served as a law clerk for state and federal judges in Massachusetts and Colorado, as Special Deputy Attorney General of Alabama, and as a lawyer in Boston. He holds degrees from Gordon College and the University of Notre Dame Law School. Arguing against the motion is Professor John Sims. John Sims began his legal career as a law clerk in Portland, Maine, for Franklin M. Coffin, Chief Judge of the U.S. Court of Appeals for the First Circuit. He moved to Washington, D.C. to become an attorney at the Public Citizen Litigation Group, a public law interest firm founded by Ralph Nader. John stayed at the litigation group for 11 years, and he handled a wide variety of cases in both the federal and state courts. Then, in 1986, he joined the faculty at the University of Pacific McGeorge School of Law in Sacramento. He remained on the faculty until he took emeritus status in the summer of 2019. John's main areas of specialization in his teaching and writing was constitutional law, and he taught such related courses as First Amendment law, federal courts, and administrative law. John also taught a number of other courses, including professional responsibility, international protection of human rights, and remedies. To both Professor MacLeod and Professor Sims, I want to extend an enormous warm welcome. This time we'd, of course, have a round of applause, but we are unable to over Zoom. But thank you to both of you very much for tonight's event. At this time, I'm going to turn over the event to our wonderful debate moderator, Carrie Firth. Carrie?
Hi, thank you, Jared. Okay, so we'll be, the professors will each be speaking for 20 minutes, And then after they speak, we will take questions. So you can submit your questions through Zoom, and we'll be taking questions until about 6:30. So when you submit your question, please state your name and whether you're from a specific organization, with the lawyers chapter, with Professor MacLeod School. Just give us a little bit of background of where you're from tonight. So with that, I'd like to go ahead and start the debate. So Professor MacLeod.
All right, well, thank you. I will imagine the thunderous applause in my head, and we will charge ahead. I want to start by thanking University of the Pacific McGeorge School of Law for hosting this, the Federalist Society student chapter, particularly Jared and his executive board team, which have done an extraordinary job pushing through all the various obstacles to making this happen. And I'm grateful also to other student group leaders and law students at both University of the Pacific and Faulkner, who are going to be with us this evening. Dr. Jeffrey Cly provides healthcare to mothers and other women in Fort Wayne, Indiana. A few years ago, one of his patients, whom I'll call Sarah, showed up in the emergency room with a severe uterine infection, vaginal hemorrhaging, severe abdominal pain, fever, chills, nausea, and vomiting. An ultrasound revealed that she had, quote, pieces of a baby inside her, and those body parts had become necrotic inside her womb. She had not informed Dr. Cly that she was pregnant, but had instead gone to an abortion clinic nearby, where the abortionist had botched the procedure and then sent her away. When Dr. Cly learned what had happened, he sprang into action and saved Sarah's life. But as a result of the infection, Sarah had to go a hysterectomy. She was 20 years old at the time. She wanted to have more children in the future, but of course she never will. Later, another of Dr. Cly's patients appeared in the emergency room with body parts inside her. I'll call her Rachel. Rachel also had procured an abortion without Dr. Cly's knowledge, and the abortionist had again messed up. After the abortion, Rachel could tell that something was wrong, but she couldn't reach the abortionist. He was only in town for 8 hours each week, had no nighttime on-call service, and did not provide his telephone number to the mothers on whom he performed his procedures. Fortunately, Dr. Cly and other healthcare professionals were able to save Rachel's life and her uterus. Now, Dr. Cly later testified to the Indiana legislature that Sarah's tragic loss and Rachel's near miss could have been prevented with proper emergency on-call coverage and quality oversight. That coverage and oversight is routinely provided by the physicians at Dr. Cly's hospital to physicians such as Dr. Cly, who have admitting privileges there. Any physician who performs healthcare procedures in Indiana is required to have admitting privileges status at some facility that provides coverage and oversight. This is how the American medical profession regulates itself and ensures quality healthcare for all the people whom it serves within its community. Dr. Cly serves as the Quality Assurance Committee Chairman at his hospital. The committee provides oversight to all of the physicians within the hospital's jurisdiction. Dr. Cly explains how it works. The committee, quote, reviews every single complication, surgical infection, and procedural complication that occurs. This allows us to ensure the physicians are not harming patients because of the substandard medical care or negligence. It also allows us to track complications and, if necessary, take educational or disciplinary action to protect our patients from harm. If I perform a dilation and curettage for a miscarriage and pieces of the baby are left inside the patient, within days, I would have more than 10 physicians from a quality committee asking me to explain myself. They would also track my complications and make sure it didn't happen again. Furthermore, Dr. Cly explains that every physician must have 2 emergency backup physicians listed who will provide emergency and nighttime call coverage should that physician be unavailable or out of town. Now, why didn't Sarah and Rachel get the benefit of this medical coverage and oversight? The reason is Roe versus Wade. Since it conferred unique privileges upon abortionists in Roe, the Supreme Court has created other special powers, immunities, and privileges which excuse abortionists from legal and professional accountability. Sarah and Rachel are not the only women to suffer the consequence of these privileges. Dr. Cly testified that women in Indiana suffer unnecessary complications from elective abortions weekly. And Indiana is not unique. Victims of the abortion industry are all over the United States. They're concentrated, of course, among the poor and vulnerable. The mutilated patients of Douglas Carpens, Ulrich Klopfer, Leroy Carhart, and Kermit Gosnell are among the most extreme cases. But their suffering is the foreseeable result of the abortion industry's immunity from law. Abortionists assert that if Roe were overturned, women would seek back alley abortions from unaccountable butchers rather than the healthcare professionals. This was Justice Blackmun's abortion mills. But this is ironic, I think, for in fact, Roe and the Casey Hellerstedt decisions that grew out of it make abortionists unaccountable to the medical profession and to basic legal standards. I have 2 points to make in the time remaining. One, the unique privileges that the Supreme Court has conferred upon abortionists are contrary to law, especially the legal interests of mothers. And two, the abortion industry's unique privilege deprives millions of Americans of their fundamental rights of life, health, and equal protection of the laws. My first point, abortionist privileges are contrary to law. Roe immunizes abortionists from general medical regulations, common law protections for bodily integrity, professional oversight, and other forms of accountability that would protect women from malpractice. Abortionists loudly insist that abortion is healthcare and that abortionists are healthcare professionals. Yet they claim immunities and powers that no healthcare professional possesses, and they refuse to accept the legal responsibilities that all other healthcare professionals bear. Every time a state legislature applies to abortionists long-standing rules governing physicians, abortionists immediately run down to the nearest federal courthouse and demand an exemption. Because of Roe and its progeny cases, they usually win. Now, every time they run to court, abortionists demonstrate that the abortion privacy privilege does not really belong to the mother, and it does not secure her right of bodily integrity. The privilege belongs to the abortionist. Justice Blackmun, who decided Roe and wrote the court's opinion, confirmed this 21 years after Roe in an interview with law professor Ronald Rotunda. He explained that the central obstacle to the result he wanted to reach, immunity for abortionists, was the law, specifically the Hippocratic Oath, the oath taken by physicians since antiquity, which prohibits battery and intentional killing and commits a physician to the mandate, first do no harm. Blackmun infamously got around the oath and the law by cloaking the abortionist's judgment in a penumbra of privacy. Blackmun said, for the first trimester, quote, the attending physician, in consultation with his patient, is free to determine, without regulation by the state, that in his medical judgment, the patient's pregnancy should be terminated. Rotunda observed, note that the right was the right of the physician, whom Blackmun assumed was male. Blackmun made this clear in Roe and in the opinion that he later authored in Singleton versus Wolf. First, consider the facts of Roe. The statute challenged in Roe did not impose criminal sanctions on women seeking abortions. Rather, it authorized punishments of those who perform abortions and those who pressure women to have abortions. In fact, the pro-life movement and the medical profession have not sought to punish women then or now, but rather have worked tirelessly against those who exploit women for monetary and personal benefit. Next, consider the reasoning in Roe. The court did not ground the abortion privilege in a woman's right of bodily integrity, life, or health, but rather in the privacy of the abortionist-patient relationship. Indeed, the ancient fundamental rights of all natural persons not to suffer a battery, to be informed by their physician of a procedure's risks, and to refuse consent are, Blackmun observed, inconsistent with the court's progressive era precedents, especially Jacobson versus Massachusetts and Buck versus Bell. Jacobson is the court's decision ratifying mandatory vaccination. It stands for the proposition, invented by the court in 1905, that the ancient fundamental common law right against battery and a physician's correlative duty to obtain informed consent provide no protection when a legislature decides to suspend them for public health reasons. Jacobson means that people may not refuse a battery if public health experts deem it necessary. Blackmun's citation of Buck versus Bell is even more instructive. In that 1927 decision, the Supreme Court upheld application of Virginia's eugenics laws, which authorized physicians to sterilize Carrie Buck without her consent. In explaining the ruling, Justice Holmes wrote, quote, we have seen more than once that the public welfare may call upon the best citizens for their lives. It would be strange if it could not call upon those who already sap the strength of the state for these lesser sacrifices, often not felt to be such by those concerned, in order to prevent our being swamped with incompetence. It is better for all the world if, instead of waiting to execute degenerate offspring for crime, or to let them starve for their imbecility, society can prevent those who are manifestly unfit from continuing their kind. The principle that sustains compulsory vaccination is broad enough to cover cutting the fallopian tubes. Holmes then cited Jacobson before opining, of course, infamously, 3 generations of imbeciles are enough. This is the jurisprudential source from which Blackmun drew to justify special privileges for abortionists. Now, in their political and cultural rhetoric, abortionists always portray Roe as a case about the autonomy of women and the liberty of expectant mothers. But that's not what Blackmun wrote in Roe. And given the facts of Roe, that can't be its holding. Roe versus Wade does not confer upon women a right to control their bodies. Women had a right to control their bodies at common law and in American constitutional law prior to 1905. The court derogated that right in Jacobson and Buck and did not restore it in Roe. Blackmun made this clearer in the Singleton case 3 years later, in which the court invented for abortionists another special legal benefit, a unique power to assert standing to challenge laws that the abortion industry considers burdensome. Standing, of course, requires the claimant to show that he suffered a particular injury as a result of a deprivation of his own right. Blackmun succinctly explained the court's decision to confer standing on abortionists. Quote, "If the physicians prevail in their suit to remove this limitation, they will benefit, for they will then receive payments for the abortion." The court went on to abrogate the doctrine of jus tertii, which prohibits a party from asserting the rights of another person. But the court has only conferred this special standing power on abortionists. It has not extended the privilege to physicians and other healthcare professionals generally. After Singleton, the abortion industry stopped the charade. Having gained standing to assert the putative rights of women in court, abortionists started asserting constitutional challenges in their own names and on their own behalf. Planned Parenthood, Patrick Manillo, James Armstrong, Leroy Carhart, and so on. Many of these men and powerful corporations obtained judgments in their own favor, exempting them from laws that protect the health of women and children. Try to name another context in which the privacy of a relationship confers upon the more powerful person in that relationship the exclusive right to speak for the less powerful member when their interests potentially conflict. Married couples enjoy testimonial privileges and other privacy protections, but the law correctly denies to an abusive husband the right to speak for his wife in court. Clergy and lawyers have duties of confidentiality, and the law affords special privacy protections to them as well. But clergy and lawyers do not enjoy standing to challenge laws which secure the fundamental rights of their parishioners and clients. The abortionist exercises his special privileges free of oversight and accountability other than the mother's consent. Now, not fully informed consent, of course, as the common law always required before Jacobson. Fully informed consent, as required by law, would involve telling expectant mothers that the abortionist has this unique legal immunity and lack of accountability to the medical profession, and that she faces unique risks as a result. Informing a mother of those facts would place an obstacle between abortionists and the procedures from which they derive their profits. Indeed, the logic of Jacobson versus Massachusetts and Buck versus Bell, which Blackmun cited in Roe, is to excuse abortionists from obtaining, in principle, any consent from the mother. Roe does not foreclose this implication. In 2012, a state court in Massachusetts ordered a young woman to undergo a forced abortion and sterilization against her express wishes. After having an earlier abortion, the woman had suffered what the court called a psychotic break, becoming agitated about her abortion and lamenting that she had, quote, killed her baby. When she later became pregnant again, her parents obtained a court order that the young woman be, quote, coaxed, bribed, or even enticed by ruse into a hospital where she would be sedated and an abortion performed. Significantly, the Massachusetts Appeals Court could find no legal ground for reversing the forced abortion order on its merits. Instead, it remanded for further evidentiary hearings. The implication is clear. Buck and Roe impose no principled obstacle to forced abortion. As long as the evidence is sufficient to support a professional judgment that abortion is indicated, courts are powerless to overrule the abortionist's judgment. Given that human lives and health are at stake, of all professions and industries, the abortion industry most needs regulation and oversight. Is it any wonder that abortionists who disassemble human bodies inside women's wombs are so often cavalier about the bodies of the women themselves? And as long as the Supreme Court continues to immunize abortionists from legal and professional accountability and confers upon them the exclusive right to speak on women's behalf, who will vindicate the rights of women against abortionists? This connects to my second point. Roe empowers abortionists to deprive natural persons of their fundamental rights, especially rights of life, health, and equal protection of the law. Citing Roe as authority, federal and state courts now routinely strike down statutes that prohibit discriminatory abortions, which target unborn women and girls rather, and the disabled. Courts enjoin the enforcement of laws that require abortionists to preserve the lives of babies born alive and of babies who satisfy legal criteria of viability. Citing Roe, courts strike down generally applicable medical norms, such as admitting privileges requirements and ambulatory surgical standards. States have compelling interests to enact those laws because they have moral and constitutional duties to enact those laws. The Ninth Amendment makes clear that the people have retained their fundamental common law rights, such as the rights to life and bodily integrity. The 10th Amendment declares that states have the power, and the 14th Amendment declares that they have the obligation to secure the rights of all persons in law and judgment. States have considerable freedom to decide how to secure fundamental rights. Alabama need not enact the same regulations as California. But our law has always recognized a small number of absolute rights and inherent wrongs. Every person has the right to life, the right not to be enslaved, and the right to keep one's limbs, precisely because the common law has always condemned the inherent wrongs of intentional killing, enslaving, and maiming. Neither the states nor 5 lawyers who work next to the Library of Congress has the power to transform an inherent wrong into a right simply by cloaking it in privacy. The persons named in the 14th Amendment who enjoy those fundamental rights are human beings. Jurists at the time of the ratification of the 9th and 14th Amendments all read their law in Cook and Blackstone, who made clear that the right to life belongs to natural persons in comparison to artificial persons, such as trusts and corporations, which owe their existence to a state's positive law. A natural person, a person who enjoys the absolute rights of life and limb, is any person who is formed as a person naturally, without the assistance of law. As Blackstone expressly stated, and as all jurists understood in 1791, in 1865, and in 1972, natural persons includes infants born and unborn. Though a minor person does not yet enjoy all the privileges that positive law confers upon persons, she cannot vote yet, for example, she's nevertheless already formed as a bearer of the absolute rights conferred upon her by the laws of nature. A minor person, like an adult person, possesses the rights not to be enslaved, defamed, maimed, and, yes, intentionally killed. For all these reasons, Roe is contrary to law, and it is contrary to fundamental rights, and it should be overturned. Thank you.
Thank you, Professor MacLeod. I appreciate your remarks. Now, Professor Sims, you have 20 minutes for your remarks.
Thank you, and thanks to Professor MacLeod for that. It's really very thought-provoking discussion. I will say that, in anticipating tonight's discussion, Professor MacLeod and I had not exchanged our intended approaches, as to what we were going to talk about. And I guess I would say that, I hadn't anticipated that we'd be putting as much focus on, in effect, medical malpractice and having less of a discussion of, say, the doctrinal aspects of Roe and the legal principles and cases that have come out of it. I'm happy to address the issues that Professor MacLeod has raised, but I would just observe that a lot of his discussion really pertains to what I would call a medical malpractice. And of course, that's to the extent that a doctor performing an abortion or any other medical procedure, or for that matter, other forms of medical treatment, acts in a way that doesn't have proper consent, or that is carried out improperly, or that jeopardizes the well-being of the patient in a way that departs from practice. That isn't just that there's a bad outcome, but that there's bad treatment. There are remedies provided. And of course, in that realm of medical malpractice, it's mainly a matter of state law, not federal constitutional law. And of course, I don't know if Professor MacLeod would be aware of it, but here in California, we have a special statute called MICRA, passed in 1975, that very particularly and really quite stringently regulates medical malpractice actions. It restricts the remedies that are available, particularly any sort of non-economic damages and recovery. Restricts attorney's fees in medical malpractice cases. So, as a matter of state law within California, medical malpractice recoveries are restricted, but it has nothing to do with abortion. And honestly, I'd never really heard the principles flowing from Roe and as carried out in the subsequent cases, culminating in the Whole Woman's Health case in the Supreme Court in 2016, striking down a Texas law, and then the follow-on this past term of the Supreme Court in the case coming out of Texas. I just never really heard those cases characterized before. I mean, I've never heard those are the typical cases where I would say the states have passed extremely stringent regulation of abortion, really, I would say, as a practical matter, in an effort to evade the application of the Roe-Casey principles, and to prevent as many abortions as possible, or if possible, to shut down the providers of abortion services. That's the typical case, in my view. And so Professor MacLeod's description of the course of the law as being one in which there's immunity for those carrying out abortions, or limited accountability in medical terms, I guess I've never heard that sphere of medical activity described that way. And I don't think it's an accurate description. I think the course of things has been that, let's say the more conventional way to describe this would be that Roe invalidated the existing prohibitions on abortion. It permitted states to continue to regulate abortion if they're inclined to do it. All states have continued to do that to some degree, particularly in the post-viability period. The recurring theme has been that the states don't like the restrictions that their regulation of abortion is under because of Roe and Casey, the follow-on case that came almost 20 years later. And they then pass statutes that they, if they were being honest, would admit are inconsistent with Roe and Casey, that impose requirements that, as to who can carry out an abortion, what staff has to be available, doctors have to have admitting privileges, what sort of physical arrangements have to be available in the clinic in terms of the design of the rooms and the rest such as requiring that in effect the clinic be a hospital in terms of its facilities, and that the states recurringly pass those statutes. And then the pattern over time has been most of those statutes have been invalidated. So those who are affected, and again, I've never really heard these principles so vigorously described as protecting the doctor's rights. I would describe these cases, and I'd be, pretty confident that most people would agree with me on this, as protecting the right of a woman to choose to get an abortion under a wide range of circumstances if she chooses to. And it's true that in some cases, those interests have been asserted in addition to being asserted by women, by providers of abortion services. But the technicalities of the Article 3 principles on standing and mootness and ripeness and the rest, there is that aspect to some of this litigation, but it's really not central in my view. I don't think that the recognition that's been given to the rights of women to assert their rights, and the opportunity for those whose interests are aligned with women who want to terminate pregnancies are in any way out of the ordinary. And so, if we have to talk about mootness and rightness and standing, I'm happy to do that, but I really don't think that's on the center line of the issues that are before us. So I would say, I would describe the recurring pattern in a way totally different than Professor MacLeod. I would say in 1973, every state, or maybe we'd have to say almost every state, regulated abortion much more thoroughly than Roe permitted. There obviously, prior to Roe, there'd been some liberalizations in a few states, but I don't think any state allowed a woman the wide range of choice to terminate a pregnancy that was recognized by Justice Blackmun and 6 of his colleagues in the 7-person majority opinion in Roe. And so after that, then there was a wholesale revising of the laws. And some states basically accepted Roe and have regulated abortion consistent with Roe, and they've hardly ever been sued for violations of Roe. And some states have recurringly tried to figure out a way to evade Roe, to not comply with Roe, to pass a statute that says, well, you can't get an abortion after 20 weeks, you can't get an abortion after 12 weeks, you can't get an abortion after 6 weeks, you can't get an abortion if the heartbeat could be detected or whatever. You can't get an abortion except in a hospital, can't get an abortion except if there are 2 doctors present, can't get an abortion unless the doctor has admitting privileges at some hospital within X miles. And, certain states, Texas and Louisiana, and Georgia, Alabama, there are lots of them, have been the defendants in these cases again and again and again, basically trying to, either see how thoroughly abortion can be regulated despite Roe and Casey and the myriad related cases along the same line, applying those leading cases from the Supreme Court, or sometimes the laws are presented as being inconsistent with prevailing law under Roe and Casey, and that's the whole point. And the idea is that the case would eventually make its way to the Supreme Court, and that the Supreme Court, this is what I basically thought the argument would be today, imagining that, we're almost back in the Supreme Court, and the argument is Roe ought to be overruled. It was either wrong at the time it was decided, or it can now be seen to be wrong, and therefore the court ought to rule differently than it did in Roe and than it reaffirmed effectively in Casey. But the proponents of these laws in Kansas or Alabama or Louisiana or Texas or wherever it is, their idea is, well, we'll blatantly violate Roe and Casey and related cases, and then the case will eventually get to the Supreme Court, and that then will provide the opportunity for the Supreme Court to overrule Roe. And of course, that hasn't happened, but if you think Roe is wrong, that is an understandable approach. What's not quite as understandable is how many times legislatures have gone along with this and passed laws that do violate Roe and Casey, and then have ultimately been held to violate Roe and Casey. That's just been a repeated pattern over the years. Let me just, I guess I do want to say just a word about Justice Blackmun. He'd been a lawyer for the Mayo Clinic for most of his career. So he definitely was very attuned to the outlook of the medical profession. And so I think some of the language about the doctor in Roe is, to modern ears, sounds a little weird. But despite his choice of words, there, especially in light of all the subsequent cases, there is no doubt that it is not the doctor's decision about whether a woman will terminate a pregnancy. It is the woman's decision. And that has invariably been recognized. Obviously, if the doctor, a particular doctor, won't carry out a desired procedure, then the woman either has to allow the pregnancy to go forward or has to find another doctor. So in that sense, the doctor, is an important part of the decision, but it's not the doctor's decision. And whatever the language that Justice Blackmun may stray into in Roe, occasionally reflecting his own background, that's not what these cases are about. I would just say that for me anyway, the law that's developed under Roe, while it's been, as I said, contested at every moment along the way, is consistent with the rest of the operation of our system. And of course, as I mentioned, Roe was not a 5-4 decision, it was a 7-2 decision. And I would just mention 4 cases that I think are not abortion cases, but they're cases that are totally woven into the fabric of our law, that if you don't accept where we are in terms of the Roe-Casey line of cases, and you imagine doing what these state legislatures and those who really oppose Roe and Professor MacLeod would like to see, you'd have to really figure out how to deal with these cases and these other lines of cases. And I say these aren't just, obviously the specific line of cases on abortion has faced the challenges again and again and again when the states have passed these statutes. Most recently in the Whole Woman's Health case and the June Medical Services case, and the outcome so far over this period of, I think it's 47 years, has been consistent. That is, this is the law, that a woman has a right to terminate a pregnancy prior to viability, and she even has a much more restricted constitutional right to terminate a pregnancy after viability if her own life or health are jeopardized. But just let me mention 4 cases. One, Griswold against Connecticut, 1965. So Connecticut has a law that really grew out of the same types of feelings that would underlie anti-abortion law. That birth control was illegal in Connecticut, and that was because at some point the people in Connecticut thought that using birth control was immoral. A lot of the people who thought that thought it for religious reasons. It was a heavily Catholic state. Efforts to get that statute repealed. So this is a classic problem in democracy. The legislature has passed a statute and it's never been repealed, and it makes the use of birth control illegal. Conventional constitutional doctrine didn't have a way to deal with that. You've even got the dissent from Justice Stewart in Griswold saying, I think this is an uncommonly silly law, but I can't say it's unconstitutional. But the majority did say it was unconstitutional. And it's true, Professor MacLeod harkens to the fact that they did use the language of privacy, which is really sort of a mislabel. At least it doesn't help us. So what we now talk about Griswold as is it's a substantive due process case. It's a case that says that there are certain things that we can say about the relationship between the state, the government, and the individual, and that there are certain circumstances in which the government can't intrude without a really good reason. And in Griswold, it happened to be about birth control. In Roe, that's applied to a decision about whether a woman who's pregnant will become a parent. Griswold, even when Judge Bork was having his confirmation hearings and his nomination to be on the Supreme Court, even he had to say, well, I can't say that Griswold was wrong. But I think if you're going to overturn Roe, you really have to basically negate the idea of substantive due process. And of course, substantive due process itself goes all the way back to a couple of cases from the 20s involving education, recognizing that, somewhat, linguistically, surprisingly, that there is a substantive component to due process. And it starts in the modern version in Griswold, and it then goes all the way through the cases that we're seeing now. So if you believe that there is a doctrine of substantive due process, which the Supreme Court has said ever since 1923, then application of it to the decision about whether you'll become a parent or not, if you don't want to become a parent and find yourself pregnant, I think that's going to be sort of a natural application of the doctrine. The second case I want to mention is Bowers against Hardwick. Of course, that's the case from 1986 where the Supreme Court upheld the idea that it was okay to make gay sex a crime. Of course, that's gone. It was overturned in the Lawrence case. But the reason Bowers comes to mind is that it's similar to a lot of the efforts to overturn Roe in the sense that it's based on a moral judgment. That is, people, many of them having very firm religious beliefs, whether based on Catholic religion or fundamental Christian beliefs of some sort, they really believe that abortion is equivalent to murder. And they, highly motivated by that thought, want to stop abortion. But that was the same, of course, with those who voted for and supported the kind of legislation that was involved in Bowers. And of course, that turned out to be a wrong turn. When the Supreme Court actually dug deeper into the issues about sexual freedom, they ended up concluding that Bowers was wrong when it was decided and would be overruled. So I think any effort to overturn Roe, because some people believe that life begins at conception, and contrary to what Roe says, that personhood begins prior to birth, that's really running uphill. And Bowers shows you can get into real trouble if you take that path. I'd mentioned also United States against Virginia. That's my third case, the VMI case, because that, of course, is the opinion in which Justice Ruth Bader Ginsburg vigorously applies the idea of gender equality as a matter of equal protection law. And of course, lurking in the current state of abortion law is the idea that if abortion is banned, then women are severely disadvantaged relative to men in our society. So that was not developed because, of course, the law of gender equality was in an undeveloped state at the time of Roe. But in Casey, there's recognition that you have to really grapple with gender equality issues if you were going to allow abortion laws, which of course affect women directly. And the other fourth case, don't have time to talk about it, maybe I can get to it, is Dandridge against Williams. And I would say the basic idea there is we have a system of rational basis review on the one hand and heightened review on the other. And if one is proposing that a choice about whether to become a parent isn't protected by anything more than rational basis review, that would have grave implications for many, many other areas of our law. Whereas now, of course, the decision about whether to become a parent under substantive due process doctrine is very protected many other decisions about wealth and about income distribution and taxation and the like are not very much protected at all because of the way rational basis review works. Thank you. I'm afraid I've used every second of my time.
Of course, thank you. So now you'll each get 7 minutes to respond. We'll start with Professor MacLeod. You can respond first.
Well, thank you very much, Carrie. Thank you to you, John, for a very well thought out and I think very measured response that sticks to the issues and avoids what is a standing temptation when we're talking about Roe and abortion and privacy interests more generally to become personal, which there's too much of that in public discourse today. So I'm grateful for your very scholarly and academic treatment of these questions. John began by suggesting that my discussion is really just about medical malpractice. That's a matter of state law. Of course, the whole point of the Hellerstedt and June Medical Services decisions was to eviscerate state laws which required abortionists to be held accountable to other medical professionals. I agree, it's a matter of state law. And that's exactly why Roe should be overturned. The matter of medical accountability should be returned to the states. As John acknowledges, Roe worked a wholesale revising of the entire history of common law when it comes to the medical profession's self-regulation. He says that my description of the way that the medical profession goes about regulating itself is not an accurate description. Well, I would just say that I got that description from the testimony that Dr. Cly gave to the Indiana legislature and a telephone interview, a rather extensive telephone interview I conducted with Dr. Cly and have since confirmed with other people in the medical profession that that's exactly how the medical profession regulates itself. Admitting privileges and ambulatory surgical centers are two of the mechanisms by which doctors hold each other accountable for standards of for complying with standards of care. So this is not about outlying. It's not as if Klopfer and the Carpens of the world are outliers. This is actually about the heart of what Roe means. Secondly, yes, it's true that the court has described the Roe case and that abortion rights proponents describe Roe as being about the woman's choice and about personal autonomy. Of course, the most dramatic expression of this was Justice Kennedy's Mystery of Life passage in Casey, that at the heart of liberty is the right to define your own concept of the meaning of life. But that's actually not what Roe held, and that's not actually what Roe is about. And the way you see this is by looking at cases of substituted judgment, such as the case of guardianship of Moe, which I mentioned earlier out of Massachusetts. In cases like that, we see the direct conflict between abortion as a protection for autonomy, which is the claim, that's what it's dressed up as, and abortion as an immunity for abortionists. People don't get health care to get autonomy. They get health care to get healthy. And when health care is given to someone who is not capable of making their own informed decisions, a minor, for example, or in the case of guardian of Moe, someone who has been deemed to be mentally unfit simply because she's suddenly become pro-life, in those cases, we see the conflict very, very sharply. And then the autonomy of the individual gives way. And when we say what these cases are actually about. I would say also that in the real world where abortion is actually practiced, autonomy generally doesn't mean freedom of choice in the way that it means to philosophers. Usually what it means for a woman who is trying to decide whether to have an abortion is just that she's alone. That's the best case scenario. There are many cases, as we know, where women are coerced into having abortions by their parents, by boyfriends, and by others. And so the idea that Roe is a security for personal autonomy just doesn't match the facts on the ground. Now, briefly, I've got to buzz through the cases that John mentioned. Griswold versus Connecticut, rightly decided, but on the wrong grounds. You can get a correct decision out of Griswold simply by adverting to the common law right of the marital contract. But of course, that would require you to look to the 14th Amendment's due process and privileges and immunities clauses, a door which the court closed in the 1880s when it got busy striking down the civil rights legislation of the 1860s and 1870s. So an original understanding of the 14th Amendment would say that the marital bedroom, in fact, is entitled to the privacy protected by law, but not on grounds of substantive due process. And the reason is very simply this: substantive due process is not law. Substantive due process is made up by judges. It's the court's opinions about which laws they think should be morally suspect. So John is very concerned about people expressing their moral views. He's concerned about his fellow citizens expressing their moral views in legislation. My concern is with judges who get the final say as to which moral views are valid and invalid. And in fact, substantive due process, of course, didn't first emerge in the 1920s. He neglected to mention two substantive due process cases which precede the 1920s, Faulkner versus New York in 1905, and of course, Dred Scott versus Sanford in 1857. So the idea that judges get to decide which moral views are going to be enshrined as rights, I find deeply problematic. And that's why I think an original understanding of the 14th Amendment is superior to one that looks to the court to invent new privacy rights and new interests under substantive due process. We could run through the other cases. You get the same result in Lawrence versus Texas on equal protection grounds. The law in Texas, unlike the common law prohibition against sodomy, specifically targeted homosexuals, obviously violation of equal protection. We could talk about gender inequalities and the ways in which abortionist immunities threaten the interests of mothers, which I've given in some detail. But the bottom line is this, that Roe is not actually grounded in law, as John candidly conceded. It worked a wholesale abrogation of the law of medical accountability. That's in addition to the fundamental rights of the unborn, which it places in jeopardy. And for both of those reasons, I think it should be overturned.
Thank you, Professor MacLeod. Professor Sims, you have 7 minutes to respond. And then after that, you'll each get a 1-minute rebuttal.
Great, thank you. I mean, I guess I would start by emphasizing that Professor MacLeod is not, as becomes, I think, pretty clear, not just objecting to Roe and Casey and the dozens, if not hundreds of cases that have applied those two decisions, but to the whole fabric of substantive due process law. And, and so I would just emphasize that idea that the relationship between the government and the individual is mediated by the idea of substantive due process, and that at least as far as certain types of interests are concerned, the government's justification for intruding has to be at a high level. That idea is obviously reflected in the abortion cases, but it also is reflected in originally Griswold itself, and through the cases on sexual freedom, leading up to, of course, the marriage equality cases. And, the ideas of equal protection and substantive due process are kind of twisted around each other in the marriage equality cases. But ultimately, it doesn't matter what label you put. If you were to apply, in other words, if you were to look at the abortion issue as just a straight gender equality issue, and you recognize then that the decision about whether a woman was going to become a parent or not was something that had to be dealt with under heightened scrutiny, it wouldn't matter whether you use the substantive due process label or whether you used equal protection. Obviously, Skinner's a good example of that, because Skinner nominally is an equal protection case, but plainly the heart of the case is about the interest that's involved, which is the choice about whether to become a parent. And so, and of course, I don't know the facts of the forced abortion cases that Professor MacLeod is describing, but I am absolutely opposed to any sort of forced abortion. And I am absolutely convinced that the law as it exists would not allow any forced abortion. And of course, Skinner is a perfect bookend on this, because in Skinner, you had an analysis. Admittedly, technically speaking, it's an equal protection analysis, but I don't think that label makes any difference in this context. But it was somebody who wanted to have the potential to become a parent, and yet that case then is cited appropriately and applied in the later cases, like Griswold and Eisenstadt and Roe, and later abortion cases for as being equally applicable to the situation when somebody chooses not to become a parent. So it's about choice. It's not about whether you are a parent or not a parent. It's about whether you get to choose about this central aspect of your existence, what for many people is one of the most important choices they'll ever make in their life, and one of the most life-affecting ones. Obviously, choice of a partner, a life partner, is also of great consequence, and that's why the doctrinal threads that all pull together between the birth control cases, the abortion cases, and ultimately the marriage equality cases, they're all the same. They're about choice. They're about whether the state can intrude and limit an individual's choice on a singularly important matter without having a high level of justification. As far as Hallerstad and June's medical, all I can do, I wasn't there at the trial, but I would say in these cases and in the typical other cases that have been decided after Roe, where state laws are purportedly regulating abortion as a medical procedure, and certainly the trial in the June's medical center case had proven that there was no medical reason for the statute. Now, sometimes the legislature tries to hide it and tries to pretend that there's some medical reason, but the critical thing is abortion is a very safe procedure. These days, half abortions probably are conducted pharmacologically. They don't actually involve any kind of a surgical intervention. Pills taken early enough in the pregnancy can terminate the pregnancy. So as far as I know, overwhelming medical evidence in those two recent cases in the Supreme Court, and almost invariably in the other cases that have been decided, was that the abortion was a very safe procedure, that the purported regulation of it as a medical procedure was really just the cover story by the legislature about whether it was the nature of the facilities or who had to carry out the procedure, or whether they had to have admitting privileges or anything else. It was all just a cover story. The real issue was preventing abortions. And all I can say is that in all those cases, and in many of them there were trials, the judges found that the purported medical justification for whatever the restrictions were failed. They could not be substantiated given how safe the procedure is. I will mention a recent book, just came out this summer. I can't say I've read every word. I've read a lot of it. It's called The Turnaway Study. It's by Diana Green Foster. And it's a study, it's sort of the real world issues that Professor MacLeod is raising. So there are 1,000 women who end up being followed up in this study. And they all had shown up intending to get an abortion. But it turned out that in the jurisdiction, whatever it was, some of them found that it was too late. They couldn't get the abortion. Others were allowed to get the abortion. So following up years later, the study was, well, what happened to these women? What difference did it make? The ones that wanted to get an abortion and got it, the ones that wanted to get an abortion and couldn't get it. And I would just say that a lot of the description that Professor MacLeod has given of the abortion process, I would think is inconsistent with the actual evidence provided in this book, which was that in general, there weren't deleterious effects for the women who chose to get an abortion, then on many criteria, they were actually better off later, maybe better off because the reason they wanted to get an abortion was because they wanted to provide more thoroughly for children that already had or children that they intended and ultimately did have in the future. So I would just recommend that book, The Turnaway Study, as a very on-the-ground study of what abortion means in the real world, because so much of what Professor MacLeod has talked about is an effort to address that, but obviously I can't address factually every episode that he's referring to, but I don't agree with his overall characterization of the big picture. Thank you.
Thank you, Professor Sims. So we'll have, each of you will have 1 minute for rebuttal, and then we'll do some Q&A we'll have a little more than 20 minutes for Q&A. So Professor MacLeod, can you go first?
Thanks again to the Federalist Society. Thanks to all of you for watching. Thanks to John for, I think, a very precise and well-argued case on the other side. The most obvious reason why Roe should be overturned is that the court in Roe declared open season on the most vulnerable among us, unborn human beings. And we all know this is wrong. As Justice Ginsburg observed in her dissent in Gonzalez versus Carhart, abortion is, quote, brutal and, quote, gruesome. And she has also acknowledged abortion puts the health of mothers at great risk. This is an independent reason why Roe should be overturned. This is why Roe remains controversial nearly half a century later and why it is not settled precedent. Roe is also bad precedent and contrary to law. Abortionists claim to be healthcare professionals, yet they use Roe consistently to escape accountability to law and to the healthcare profession, and to deny to the women sitting in their clinics the right of fully informed consent. They escape the law by exercising their unlawful power to speak in court on behalf of those very same mothers. It's time for Roe to go the way of all bad precedents. Roe should be overturned. Thank you.
Thank you. Professor Sims?
Hi. I'll just say the Carhart case, of course, dealt with really late-term abortions. And I think everybody recognizes that abortion becomes more dangerous later in the pregnancy. Most abortions occur in the first trimester, and as I say, a lot of them now are carried out through the use of a pharmaceutical product of some sort. And my understanding is that if a woman has an abortion late in pregnancy, it's usually because her own life is very much in jeopardy due to the nature of the way the pregnancy is developing. And of course, the state is allowed under Roe in later cases to totally ban abortions after the viability, which would be somewhere toward that period of the last trimester. And it's the only exception to that would be where the woman's life or health was in jeopardy. So therefore, whatever is said in Carhart about these extreme situations of late-term abortions, which are very uncommon, just isn't really relevant to the debate that we're having. And all I could say is, again, is to repeat that idea from Skinner and Griswold and Eisenstadt and Roe on through the marriage equality cases in Windsor and Obergefell is that the government can't interfere with our most intimate, personal, life-altering decisions without a good reason. And that basic core idea of Roe, I believe, has been validated by the experience. And that's why, even though we've had dozens of justices that have passed on it in the 47 years since it was adopted, it remains the law. And of course, we haven't talked about stare decisis. Obviously, to change a precedent that's been so frequently reconsidered and applied would itself be highly destabilizing and, I believe, inconsistent with the idea of stare decisis. But we haven't really focused on that issue yet today. Thank you.
Thank you, Professor Sims. So now we're going to take questions from the participants. You can go ahead and, if you have any questions, type them into the Q&A section. We have a question here it's for Professor Sims from Wendy Bedingfield. She's a law student at Santa Clara Law and a member of the Federalist Society there at that law school. Her question for Professor Sims is the choice to become a parent necessarily taken away from a mother merely by giving birth to a child when alternatives are freely available to them?
Yes, I believe, I mean, at least, of course, I've never been pregnant, but I am familiar with the process, and I have had many discussions, and of course, I've read a lot about it, and I believe that the process of being pregnant, of going through the pregnancy, dealing with the physical and emotional demands of that, is, you know, about as extreme as anything that a person can experience. And of course, childbirth itself is an extremely dangerous and a painful experience for a woman. And you know, it is, one could say, oh, well, we're not saying that you have to become a parent and bring up the child. We're just saying you have to go through the pregnancy, and then after the child is born, you can give the child up in adoption. Well, first of all, a lot of people won't do that. And the Turnaway study has a lot of personal stories in there about women who wanted to get an abortion and weren't allowed to because of the point at which they showed up at the clinic, and had the child and raised it. And of course, they see the good side of that. But the idea that no immense imposition was being made on an individual by requiring a woman to carry a pregnancy to term against her will, I think is just totally wrong. And even if you decided to give a child up after birth, I mean, as it happens, my children are adopted. And I remember one of my children saying to me once, you know, well, do you think my birth mother thinks about me? And, you know, I could respond, you know, in the most heartfelt way, I'm sure she thinks about you every single day. And so to treat even pregnancy as a dramatic event, childbirth is a traumatic event, is a dramatic and sometimes traumatic event. And so those alone are immense experiences. But even if you treated that as all we were talking about, and then the child was going to be brought up in another home, the consequences for the woman who was involuntarily required to become a parent against her will would remain immense. And so therefore my bottom line would be, if you have any idea of any sort of heightened scrutiny in any context, whether it's under the rubric of equal protection or of substantive due process, then the decision about whether to become a parent has to be within that specially protected realm.
Thank you. So the next question is from Jared Dobbs, our McGeorge chapter president. And he has a question that's for both professors, so we'll let Professor MacLeod answer first, since Professor Sims got the last question. Jared's question is, should a court overturn Roe by applying the substantive due process law test of Washington v. Glucksberg? Would this cause less disruption to the case law?
It would certainly cause less disruption. My own preference, of course, is that the court should overturn Roe because Roe is unlawful. In other words, the court should return to the law, all that law that it uprooted and tossed over in 1973. Now, if we're going to have a substantive due process doctrine, I think the Washington versus Glucksberg test is the best test. The Washington Glucksberg test, of course, is those rights that are so fundamental to ordered liberty that we can't do without them. Or sometimes it's expressed as those that are so deeply rooted in our history and tradition. The common law, of course, had two different classes for these kinds of rights. There were those immemorial customary rights, like the right to trial by jury, for example, the right of due process itself. We just can't remember a time when we did it any other way. Those rights are fundamental. And then the rights that are secured by prohibitions of wrongs that are mala in se. It's inherently wrong to kill. It's inherently wrong to maim all persons, all natural persons. And precisely because of that, there are fundamental rights, the common law jurists would have called them natural rights, which no legislature is competent to abrogate. Now, within that framework, there's actually quite a lot of room for states to specify abortion laws in different ways. One obvious way it would be to have exceptions for the life of the mother. And the reason is that a procedure done to save the life of the mother is not an abortion. It's just not. The purpose for that act is not to kill the child. The purpose of that act is to save the child's life. And under the doctrine of double effect, which the court has ratified in Vacco versus Quill and Washington versus Glucksberg, that is not an intentional killing. And so it would not be a deprivation of anyone's fundamental rights. And then the final thing I'd say about Washington versus Glucksberg test is it does leave open the opportunity for state legislatures to craft new ways of dealing with old problems. And so there need not be one size fits all solutions the way that Roe demands. Alabama and New York can go different ways in dealing with these very, very difficult, complex problems, as long as they're protecting and securing the rights of everybody.
Of course, Glucksberg is the case where there was a traditional state statute in place that forbade assistance in suicide. So somebody who wants assistance from a doctor at the end of life, who is Lou Gehrig's disease or incredibly painful cancer or whatever, wants to have it be okay for the doctor to assist. That was an effort by those that were in these dire circumstances to invoke the line of cases from Roe on through the other substantive due process cases to say, well, if you're allowed to negate a state law that prevents you from getting an abortion or a state law that prevents you from having gay sex or whatever, then by the same token, shouldn't you be allowed to negate a state law that forbids physician assistance in suicide? Because, I mean, what ultimate decision is there for a human being to make, even beyond the decision about whether to be a parent or about who to choose as your life partner, than the decision about when your life has become so painful and so limited that it's not worth living anymore. And that was the argument. And there were actually two cases, and it really shows I would think I would argue it confirms my theory that it doesn't really matter whether you label these cases substantive due process or equal protection. So there was the Glucksberg case. There was a companion case of Vacca against Sipes. One of them, I can't remember which is which. One of them is a substantive due process case. The other is an equal protection case. In the lower courts, the claimants had been successful. They get to the Supreme Court, and the Supreme Court basically draws a boundary around Roe and related cases. It says, oh no, this matter is still in the rational basis world. So this is a prime application of an idea like Dandridge against Williams, which I mentioned. There is a world of heightened review. There's also a world of rational basis review. End of life is not in the same category as right to terminate a pregnancy, use birth control. Ultimately, of course, it was later that the cases were decided, marriage equality. So therefore, Glucksberg doesn't really say anything about Roe, except that Glucksberg refuses to extend the Roe idea to apply to a different set of circumstances. And, you know, the arguments were all different there. But I would say, again, the invocation of Glucksberg emboldens me to restate that, you know, we can't lose sight of the immensity of the changes that Professor MacLeod is proposing, because that idea of substantive due process and a protection for a woman's right to choose to have an abortion is interwoven with gender equality, with other applications of substantive due process, and the idea that Roe could be discarded based on, you know, common law ideas. Of course, we're not talking about the common law. We're talking about the constitutional law of the United States, and these constitutional doctrines from 1973 have developed in extremely interwoven and interrelated ways. And so the idea that this central aspect of our constitutional law is going to be pulled out and somehow there won't be any bad consequences other than the protection, as Professor MacLeod would like to see it, for the potential life in the womb, I think that's not really a very realistic notion.
Thank you, professors. Okay, I have a question from Alex Haggard, and it looks like it's to both of you again. What would abortion law look like if Roe is overturned? To what extent would the effect differ based on the court's rationale? So Professor MacLeod, I'll let you go first on that.
Okay. Yeah, it would absolutely depend on what the court's justification is. So, of course, the view of someone like the late Antonin Scalia would be that the Constitution simply has nothing to say about abortion, and Roe should be overturned on the very simple basis that this is a matter that should be left to the states. As I've indicated, I think that is actually not a correct understanding of the 14th Amendment. I think the 14th Amendment protects the fundamental rights of all natural persons, and it protects the privileges and immunities of all citizens. So I think it's very clear that a better understanding of the 14th Amendment would commend a decision saying, no, the states have not only do the states have no power, now I'm getting a double negatives. Not only do the states have the power to protect the unborn and mothers, they have the obligation to do so. Now, if we went that route, now if we went the late Justice Scalia's route, of course, you would have a great variety among the states. The states would be all over the map. You'd have some states like New York, which allows abortion right up until birth, and on some interpretations of their recent statute, even after birth. You have some states like Alabama that would prohibit it much, much earlier. If we went with an original understanding of the 14th Amendment, we would secure the rights of the unborn natural persons and the rights of mothers by allowing states to regulate the abortion industry. But that doesn't mean that the states have to use criminal sanctions. It doesn't mean that they have to use any particular civil remedies. The question of what remedy is best to secure these fundamental rights is in fact itself a question open to great variety. But the rights themselves are not. That's the important thing to note. So yeah, it would matter what rationale the court used. But I do think that a proper understanding of the 14th Amendment would obligate the states to undertake some effort to protect vulnerable human beings.
Well, I would just call attention to the fact that Professor MacLeod's formulation would be really immense in its consequences. So whereas the current state of the law is states are permitted to regulate abortion in terms that are consistent with Casey and cases that have been applying it. If one views a fetus as a person that can't be deprived of life, liberty, or property without due process of law, then, as Professor MacLeod is suggesting, the state would have an obligation not only not to prohibit abortions, but basically to prevent them. And then, of course, you have many ancillary. I mean, if that were to be, it's almost unimaginable to contemplate a change in the law that would be that dramatic. But I think then, of course, there are many issues about, well, it takes then an intrauterine device, operates by preventing implantation of a fertilized egg. Is that fertilized egg to be considered a person, an ectopic pregnancy? Is that a fertilized egg that's growing but in an inappropriate and inhospitable spot in the fallopian tube? Is that to be considered a person? I mean, there has been some proposal in legislation recently where the most anti-abortion state legislatures have proposed that there be a requirement that an ectopic there be an effort made to extract the material that's growing in the fallopian tube and then attempt to transplant it to some other place where it could mature into a person. So I don't, it's just, all I can say is if any of that were to become the law, the changes would be almost unimaginable. I think a more usual way of thinking about this would be along the lines as Professor MacLeod has described. Well, okay, states are free to regulate abortion, and some states may almost totally prohibit it. Maybe they will attempt to totally prohibit it, even in the case where the mother's life is in danger. Maybe there would be a separate constitutional doctrine to deal with that. What about rape? What about incest? But some states would do their very best, consistent with what we've seen already, to stop all abortions. Other states would, like California and New York and various others, would presumably continue to allow abortions along the lines of current law. And I would predict that the next thing that would inevitably happen would be that the states that believe that abortion is the equivalent of murder and are legislating along that line would then try to, I don't believe they could do it constitutionally, prevent their residents or those living within their borders or going within their borders who then find out that they're pregnant from going to some other state to get an abortion. Because if you believe that that's murder, well then how could you allow someone to leave your state and go commit a murder in California or in someplace else? So all I could say is that the recognition that any overturning of Roe after 47 years and after its reconsideration in Casey and its application in so many hundreds of cases would be really destabilizing and almost unimaginable in the scope of its reverberations. I believe that's true. I don't think anybody can say what they would all be. Obviously, there would be very strong political and social and economic reactions. And I would just again mention gender equality. We now live in a society in which increasingly the idea that men and women are entitled to function equally as members of society is fairly broadly accepted, and certainly much more broadly accepted than it used to be. And to the extent that a woman who becomes pregnant does not any longer have a choice about whether she's going to carry that pregnancy to term and have a child, then her status in society and her sphere of activities in society and her efforts to achieve equality in society, I believe, would be dramatically affected, such that it may very well be that even if you totally wiped out the doctrine of Roe, if the court really looked at it, they would be forced to reach the same conclusion as they did in Roe on grounds of equal protection law with regard to gender equality.
Thank you. So we have about 7 minutes left. There's several questions, but I think we only get to one of them. Again, it's for both professors, so just try to keep it brief to a couple minutes, if you can. Justice Blackmun made, this is from Geneva Lewis, and she says, Justice Blackmun made it clear in Roe that the case did not determine when life began. Relying on extensive medical and historical, missing a word, maybe research, he referred to the church's historic view that life does not begin until quickening. Is the argument that Roe abrogates medical oversight actually peripheral to the main argument that medical abortion should be banned outright?
I think all I have to say would be, I believe that what Roe holds is that personhood for constitutional purposes doesn't begin until birth. And that therefore, whatever one thinks or says or believes based on religion or anything else about there being a person from conception or at any time prior to birth, that's not a constitutionally based contention. And it's inconsistent with what the Constitution says.
It's three things to say about that. First of all, he didn't actually say the church's historic view. He said it was the medical profession's view. And it wasn't that life does not begin until quickening. That was not their view. They said the best evidence of when life begins for many, many centuries before we had very good studies of embryology was at quickening. So they all agreed that all natural human beings are natural persons. It was a question of, it was an epistemological question. When can we know when we have an alive person? When embryology got better in the middle of the 19th century, the medical profession, not the church, the medical profession, not lawyers, the medical profession said we must not be complicit in murder. And that's when all of the statutes which the court struck down in Roe began to be enacted in states like New York, for example, when the American Medical Association insisted on this. So as the embryology got better, as our knowledge got better of what kind of being we're dealing with, a human being, the medical profession said, we don't want to be complicit in this act. The second thing is he says in one place that he's not determining when life begins, but then he says in a different place, but if human life begins prior to viability, then the entire case collapses. So in fact, he did determine, he made a determination, he just doesn't give any reasons. He made a necessary premise of Roe is that life does not begin until sometime after viability. That's not grounded in medical evidence. That's not grounded in any of his research. He made it up. And in fact, all of the research which he cited points to periods earlier than viability. Quickening was, of course, the standard, but that time became earlier and earlier, not later and later, throughout the 19th and 20th centuries as our understanding of science and medical realities improved. And then the third thing I would say, just response to the question itself, no, these two things go together. Protection of the life of the unborn human being and the protection of the health of the mother are very much intertwined. Let's not forget that it is in a mother's uterus that a unborn baby is growing and developing. They're very much interdependent agencies. The abortion industry falsely advertises this ideal that being rid of children who are a burden is somehow going to enhance one's autonomy. It's false advertising. As a parent of 5 children, I'll tell you, it's false advertising. Yes, children are a burden, but the joys far outweigh the burdens. And I want to say to everybody listening, especially young people, don't fall for the false claim that by enhancing your choices, the abortion industry is somehow promoting your health, your well-being, and your ultimate flourishing. Thanks.
Thank you. Well, I appreciate both you, Professor MacLeod and Professor Sims, for participating in this debate. I wish that we'd been able to get to all the questions. I think we could have talked about this for a long time. It's very fascinating. And thank you, Jared, and the other McGeorge FedSoc board members for putting this on. I really appreciate it. And the participants, thank you for attending. And hopefully this was an enjoyable and enlightening discussion. And I hope everyone has a great night. Thank you so much.
Thank you all. Appreciate it.
Thanks very much. Enjoyed it.
Okay, bye.
For more understanding of law, rights, and each other, see my new book, The Age of Selfies, Reasoning About Rights When the Stakes Are Personal. And visit my website, www.adamjmacleod.com.